Kiiza Besigye to be tried by this court. The objection was dismissed, but immediately thereafter, the defense team raised an issue that it thought requires the reference to the Constitutional Court. The following the issues raised: one, whether or not the accused enjoys the right to a fair hearing before this court. Two, that Section 128F of the EPF Act is not clear. Three, that this court is not independent and impartial. Four, that this court has no jurisdiction to try civilians. Five, that Regulation 63(2) of the Rules of Procedure makes this court not independent. Six, that Regulation 69(2) of the Rules of Procedure makes this court not independent. Seven, that there is a question of freedom from discrimination in line with Article 21 of the Constitution. Eight, that this court has no jurisdiction over offenses of unlawful possession of firearms under the Firearms Act. Counsel for the accused made lengthy submissions and cited to this court a number of authorities to support their arguments, and pray that this court be pleased to allow the application and make a reference under Article 137 of the Constitution. In reply, counsel for the state opposed the application and submitted that some of the issues raised were determined by the Court of Appeal, which also sits as a constitutional court, and cannot be referred to the same court because the state appealed to the Supreme Court. Counsel further submitted that there are other sections in different enactments which gives court jurisdiction for offenses committed also in Uganda AG, the Penal Code Act, and Anti-Terrorism Act. So UPDF Act is not unique. Counsel also cited cases to support the arguments and submitted that since there is an order for stay of execution in the Kawazuluka case, that is why this court maintains hearing of the cases under Section 117 G and H of the EPDF Act. On the regulations 63(2) and 69 of the EPDF regulations, counsel submitted that the judge advocate under regulation 63(2) advises court, and where court finds otherwise, they have to give reasons in writing. For regulation 69, that this court seeks guidance from appointing authority on matters of law, counsel submitted that it does not happen. In his joinder, counsel for the accused retaliated earlier prayers that this court allows the deference. This court, after listening to the submissions of both counsel, considered the relevant laws cited and specifically Article 137 of the Constitution has deliberated on this application and finds as follows. One, that most of the points raised have been decided upon by the Court of Appeal, which also sits as a constitutional court, but the state appealed to the Supreme Court. Two, that the alleged defect in a charge sheet is a matter that can be resolved through an appeal to the Court Martial Appeal Court. Three, that Regulation 69 is an old regulation which has never been applied because it is not in conformity with the EPDF Act and the Constitution. Four, that the reading of Article 137(5) is that A and B have to be read together and not in isolation. Five, that the word may in Article 137(5)(a) gives this court the authority to give its opinion whether the questions advanced involves a substantial question of law, and where a party to the where a party to the proceedings requests for interpretation, the court has to agree or disagree whether to make a reference or not. In the result, this court finds that since most questions raised were decided upon the Court of Appeal, which also sits as a constitutional court, and the matter is on appeal, especially in the Kabazuluka case, this court declines to make a reference as read by counsel for the accused. This court will continue hearing the cases following the order of stay that was given by the Supreme Court, and the application is hereby declined. The accused should take plea. Isoro done at marking this 14th day of January 2025 under my hand and seal of this court. On that note, Council collaborators proceed. You talk after.
We have instructions under the Act, section 225, to appeal that particular group. Subject and this particular provision, Mr. Chairman, provides that the party to the proceedings of a unit disciplinary committee or court-martial, other than a field court-martial, who is not satisfied with this decision, shall have the right to appeal to an appellate court on any or of the following matters. A, the legality or propriety of any or all of it. A, the legality or propriety of any or all the findings. So the accused persons are aggrieved by the decision on this case. And under this particular provision, they are zealous, they are appealing the appellate court within the framework of this particular act. So we pray that it will be permitted to proceed.
No, Council, I'm not permitting you this time. Since morning, we have talked about almost all laws, and you have been debating on the same laws. Let's finish this process of taking, and others will follow. Yesterday, we are done with Captain Ora on count one. And the issue came when Colonel that Dr. Kiiza was supposed to take plea. And now to Colonel that Dr. Kiiza on count one, as you had yesterday. Do you accept or you don't accept?
Mr. Chairman, do I have the right to appeal the ruling that you have just made, or I don't?
I think the appeal is done on the final decision of court, not on the ruling. So let us proceed.
And I believe that Council knows, but
Mr. Chairman.
Mr. Chairman,
then now what are you appealing about?
we want to notify you that section 25 that a party to the proceedings of a unit disciplinary committee or court-martial, other than field court-martial, who is not satisfied with the decision, shall have the right to appeal on appellate court on any of all the following. One, the legality of the propriety of any or all the findings. The legality of the whole or part of the sentence. Security or immunity. It doesn't say that the final findings. So we are saying that this section gives our clients the right to automatic right, which is not debatable because it uses the word shall. If the framers did not want people to appeal at any stage of the trial, they would say so, and say that you can only appeal on the final orders. That is not the wording. So we would want to ask for copies of proceedings and copies of proceedings and ruling to enable us to appeal.
I think, sir, I have been clear. There is no appeal against the ruling. I have appeal on the final decision of the court. The one interpreting the text, which is the right one. We are going to waste a lot of time.
No, listen, I don't know which justice you are talking about because it is for both sides, for us all. Taking plea does not mean that the case is concluded. In fact, it is almost as if it has not started. So, taking a plea does not mean that the case is concluded, and I'm not allowing anybody to submit until we first finish this process. So can you tell Dr. Kiiza once again,
Mr.
do
Chairman,
you accept or do you not
I
accept?
decline to take the plea.
A plea of not guilty entered.
Sure.
That is the law.
Haji Obed, Lutale, have you heard and understood the charge read to you on count one?
I decline as I call it.
Not guilty entered. On count two, statement of offense. Featured under section 127 D of the PDF Act, cap 330, particulars of offense. Captain Dennis Ora, Colonel Retired Dr. Kiiza Besigye, and Haj Obed Lutale between February 2023 and November 2024, having provided information regarding meetings to solicit for logistical support with the intent to introduce the security of the defense forces, consciously withheld the said provided information from the proper authorities. So, Captain Dennis Ora, have you had understood the charge read to you on count two?
I have heard and have understood.
Do you accept or you don't accept?
No, I don't accept.
Approved, not guilty, enter the count. Dr. Colonel, that Dr. Kiiza Besigye, have you had understood the charge read to you on count two?
I decline as before.
Approved, not guilty, enter. Haj Obed Lutale, have you had understood the charge read to you on count two?
I also decline as before.
Approved, not guilty, enter. Statement of offense on count three, and unlawful possession of firearms under section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel that Dr. Kiiza Besigye and Haj Obed Lutale on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, they are found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily a monopoly of the defense forces. Colonel Dr. Kiiza, have you had understood the charge read during count 3?
Yes, and I decline as before.
A plea of not guilty entered. Hajj Obed Lutale, have you had understood the charge read during count 3?
Yes, but I decline.
A plea of not guilty entered. Statement of offense on count 4. An unlawful possession of firearms, Code Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel Retired Dr. Kiiza and Hajj Obed Lutale on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of a pistol model HB 1015 1953, which is ordinary monopoly of the defense forces. So, Colonel Retired Dr. Kiiza, have you had understood the charge read during and count 4?
I decline.
A plea of not guilty entered. Hajj Obed Lutale, have you had understood the charge read during count 4?
Yes, and I decline.
A plea of not guilty entered. A statement of offense on count 5. An unlawful possession of ammunition, Code Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel Dr. Kiiza and Hajj Obed Lutale on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of live ammunition, which is ordinarily monopoly of the defense forces. So, Colonel Dr. Kiiza, have you had understood the charge read during count 5?
As before.
A plea of not guilty entered. Hajj Obed Lutale, have you had understood the charge read during count 5?
Yes, I decline.
A plea of not guilty entered. State.
That the case be adjourned to 3rd of February for further method, and the accused persons be committed to their respective detention centers. 3rd February.
Mr. Chairman,
It's a trying time. Trying moments. These are trying moments.
Thank you, Mr. Chairman. Mr. Chairman, two requests for applications. The first one is in respect to section 225, which my colleagues alluded to. And I'm raising in light of the actors of the JA. JA took review of the appeal, when the right to appeal is going to be exercised at the final stage, as I understood. I hope I'm not misquoting. Mr. Chairman, the reading of section 225, we read it a little slow. It says, apart to proceedings of the unit disciplinary committee or court martial other than a field court martial who is not satisfied with its decision shall have a right to appeal to an appellate court on any or all of the following matters. Mr. Chairman, 2251A says the legality or propriety of all or any findings, and B, the legality of the whole or part of the sentence, and C, the severity or leniency of the sentence. Because this is a court, and the matter before this court is of a criminal nature, Mr. Chairman, the finality or the final decision would come with either a sentence or an acquittal. And perhaps that is where subsection 1, paragraphs B and C apply. Subsection 1, paragraph A does not apply to a sentence, but applies to the legality of all or any finding. Mr. Chairman, a decision in this case is a finding. We want to distinguish it from a judgment, which even though is a finding, is not a final finding. So in this case, there was an objection raised regarding whether or not the accused persons, A2 and 3, should take plea. They exercise their rights to raise an objection. The objection, as we have heard from the ruling handed down by the court, has been declined or has been dismissed. And that, in our view, is a finding and also a decision. It's not a decision in the context of a sentence so that A and B of subsection 1 can apply. It is a finding regarding the objections raised, one, and also the questions for a rephrase. So it is our request that, unlike the advice of the JA, the right to appeal envisaged in section 2251A and B is not at the end of proceedings. It is in respect to the legality or propriety of any finding, including the finding which the court has just handed down. So we do pray that the court permits that the accused person exercises their right to take the decision regarding the application for reference to the higher court. Two, Mr. Chairman, is that in exercising their right to appeal, that the sections envisaged in sections 27 is section 227, 1, 2, and 3 requires the filing of a notice of appeal and also a memorandum. The memorandum can only be produced because the memorandum states the grounds of appeal. We can only fine-tune them when we have obtained a record of the proceedings of what transpired in the submissions yesterday. The state has asked for up to 3rd of February. Today is the 14th. We have 17 days to end January, plus 3 is 20. We request the discipline force to, in the interest of the accused persons, to use these days to prepare a tight record of appeal, which can be availed to counsel. So, record of proceedings, which can be availed to counsel, such that they can pursue the remedy available under section 225, which is the right to appeal. Mr. Chairman, in the other courts, there is a distinction, or in the law setting up the other courts, there is a distinction where a right of appeal is granted as of right, and where a right of appeal requires the permission of the court. In this case, it says that the accused person who is a party to proceedings, would be the state, or the accused person, has a right to appeal. That right, therefore, is not based on the permission of the court. So we are not seeking leave of court to appeal. We are advising the court that the accused person has got the right to appeal, and exercising that right, they are therefore asking to be supported as the law envisages, so that they are availing a copy of the record of proceedings, prepare their grounds of appealing the memoranda. We also request that the court avails us a ruling, one which has been delivered a few minutes ago, and Mr. Chairman, you made an order that we avail a copy of the ruling in light of the objection which were availed today. The registry and the state have not done so. They are not yet, because the order made by the chairman was lawful, they are not yet committing the service offense of disobeying lawful orders. So we hope that they will oblige, because the ruling has been delivered, has been signed, and perhaps that in your presence, they will do at least that one of giving us the copies of the rulings which are ready. Otherwise, we are likely to see our land friend Colonel Raphael on the 3rd of February when we are lodging our application for contempt of your orders, Mr. Chairman.
I think in council for the record of proceeding, that one has no problem, given the rulings that we have made. Have no problem, maybe on the matter of Road JA.
Before the day comes in, when court pronounced that it had no problem in stating the copies, the state and the registry did not oblige. So we don't know that they understood no problem to mean give them. But we ask Mr. Chairman that the court commands that please hand over those rulings now because they are ready.
I think, sir, let me clarify on those issues. The question of the record of proceedings, the ruling you are talking about, the registry falls under my office. As you can see, we have worked throughout the whole day. There is no way we are going to force the registrar to hand over the ruling now. You can come.